We now come to chapter 2, which is the corporate insolvency resolution process, which is the operative part after the segment of chapter 1, which was on the definitions and the preliminary aspects relating to the code. Section 7, persons who may initiate a corporate insolvency resolution process. Before that, I must just mention to you one thing. Ever wondered why for a code that's called Insolvency Bankruptcy Code, the term insolvency is not defined? It's because as per this code, insolvency is taken as a temporary state when somebody's assets are not sufficient to meet one's liabilities. So typically what's happening is, if insolvency is untreated, for an individual it goes into bankruptcy, and for a corporate it goes into liquidation and the eventual winding up. So this chapter actually deals with how to resolve an insolvency, a situation, so that's why it's called the corporate insolvency resolution process. Incidentally, the term bankruptcy comes from bank, which is B-A-N-C, which is Italian for a bench, and ruptus, which is to break. So apparently in Italy, all these merchants used to sit in a room and trade, and if one of them was found uncreditworthy, they used to break his bench so he can't come back to the trading. So he's a bankrupt. So that's just a short respite on how this word bankruptcy evolved. And there are basically two strong tests for insolvency. One is called as the cessation of payments test, and other one is the balance sheet test. Typically in all the other acts that we had in India, or we have in India, it's the balance sheet test. See, for RDBA it has to be an NPA. For SURFACI again it has to be an NPA. Whereas under this act you are allowed to treat an incipient sickness case also. Why? Because it only uses the term default. So if I have not paid a bank on June 30th, which is my due date, on July 2nd it's a default. July 1st it's a default. So that's what triggers actions under part 2. So persons who may initiate the corporate insolvency process under section 6, where any corporate debtor, and who's a corporate debtor? A corporate person who owes debts is a corporate debtor. Where a corporate debtor commits a default, financial creditor, operational creditor, or the corporate debtor himself may initiate the corporate insolvency resolution process in respect of the corporate debtor in accordance with the provisions of this chapter. 7. So we come to the first initiation. It can be by a financial creditor. Financial creditor, either by themselves or jointly with other financial creditors, may prefer an application to NCLT where there is a default for corporate insolvency resolution. Explanation: a default includes a default in respect of a financial debt owed not only to the financial creditor who is the applicant, but to any other financial creditor of the corporate debtor also. The financial creditor may make an application in such form and such manner as may be prescribed, with such fee as may be prescribed. These are actually contained in the application to adjudicating authority rules. The financial creditor shall, along with the application, furnish a record of the default, the name or any other evidence of the default, whether it's from the information utility or otherwise. 2. The name of the RP proposed to be acting as the IRP. 3. Any other information as may be stipulated by the board. Please note the use of the word shall here. He shall appoint a resolution professional, or he shall name an RP in the application. The adjudicating authority, and another thing under this code is any adjudicating authority is 14 days. The adjudicating authority within 14 days shall ascertain the existence of default from the records of an information utility or on the basis of other evidence furnished in the application. Where the adjudicating authority is satisfied that a default has occurred, the application is complete and there is no DC proceeding against the proposed resolution professional, it will admit the application. Default not occurred, application not complete, or RP has a DC case, it will reject the application. Provided that the AA, NCLT, shall give 7 days notice to the corporate financial creditor before they reject the application. So he has to be basically given a chance to rectify. And the corporate insolvency process okay, shall commence from the date on which the application is admitted and orders are passed therefore. And a copy of the order shall be given to both the financial creditor and the operational creditor. And 5A and 5B. Yeah, okay. Sorry. So if the application is admitted, they have to give a copy of the order to both the debtor and the creditor. If it is rejected, the order shall be given to the creditor only, whoever has applied. The order shall be given within 7 days of admission. So what's the important feature of this application? Is that first of all, a financial creditor can apply. He can apply jointly. He can apply where there is a default to some other financial creditor of the corporate debtor. There's an application format. There's a fee of 25,000 to be paid. Incidentally, this application is in Form 1 of the Application to Adjudicating Authority rules. The financial creditor shall provide record of default, the name of the RP and such other information as may be specified by the board. Within 14 days, the AA has to adjudicate on the default and admit, and they actually use the term ascertain the default. And when they are satisfied that the default is existing, the application is complete and the RP has no DC, they can accept, else they will reject. But they have to give the applicant 7 days time to be heard. And after passing an order either of admission or rejection, if it's admission, within 7 days they have to give a copy of the order to the debtor and to the creditor. If it's a rejection, they give it only to the financial creditor. The next is section 8. Now for financial creditor, just an default is enough to go for an application. But if it's an operational creditor, there is one more process loop, which is the service of a demand notice. Demand notice or a copy of an invoice just to confirm one last time with the operational creditor that he is indeed not paid and he is not proposing to pay. So here the operational creditor shall furnish a copy, shall furnish a demand notice to the corporate debtor in such form and such manner as may be prescribed, which is basically Form 3 and Form 4 of the Application to Adjudicating Authority rules, and give the operational creditor 10 days time to respond. Okay. Now, in response to the notice, what are the things that can happen? He can say, okay, I'm just going to remain silent. Or the operational creditor can highlight the existence of a dispute, if any, and existence of a dispute. He can't highlight the dispute after I have received the demand notice. Existence of the suit, if any, and the record of the pendency of suit or arbitration proceeds filed before the receipt of such notice or invoice in relation to the dispute. 2. If he has repaid, he'll send an attested copy of the record of electronic transfer or attested copy that the operational creditor has actually encashed the check. Right? For the purpose of this section, a demand notice means a notice served by an OC to the CD demanding repayment of the operational debt. OC means operational creditor, FC means financial creditor, CD means corporate debtor, and I will use the term NCLT or NCLAT for this chapter. So this is the additional process loop, and the next is application by the operational creditor. Now the operational creditor can prefer an application. Now, before I go to that, although I'm going to be teaching you a separate session on the various case laws, but when talking about dispute, please remember the case of Kirusa and Mobilox. It's very important. That's your landmark judgment. It's actually gone to the Supreme Court also now, and the orders have come. It's Kirusa versus Mobilox. Then you have application for initiation of corporate insolvency process by an operational creditor. After the expiry of period of 10 days from the delivery of demand notice or invoice demanding payment, if the operational creditor does not receive payment from the corporate debtor or a notice of dispute, then he shall prefer an application which shall be in Form 5 to the Application to Adjudicating Authority rules, along with 2,000 rupees, What shall accompany the application? Very logical. The application has to be there. A copy of the demand notice or the invoice demanding payment. An affidavit that there is no notice to the dispute. And most important, is a copy of a certificate from a financial institution maintaining the accounts of the operational creditor, confirming that there is no payment of the unpaid operational debt by the corporate debtor, and such other information as may be specified. So please remember, I need to prefer the application, the demand notice, certificate from the financial institution, and an affidavit that I have not got paid. Now, there were 3 cases, which again I shall refer to later, where the application was rejected because the operational creditor could not give this certificate from a financial institution because they were based abroad. It was Smart Timing Steels, Macquarie Bank, and DF Deutsch. In all these 3 cases, they said a certificate from a financial institution is a must. And incidentally, what is a financial institution under this code? We saw it in the earlier chapter. It is a scheduled bank. It is a financial institution defined under 45I of the Reserve Bank of India Act. Or it's a public financial institution as defined under the Companies Act. Or any other financial institution as may be notified. So, somebody who's not coming under this definition is not even a certificate, it's not a financial institution. So, this was also held in detail, and this is the established position now. So, again, the adjudicating authority within 40 days shall establish the default, and they can either admit or reject the application. What are the grounds for rejection? If the application is not complete, if there is a dispute, if the payment has been subsequently received, if the notice or the invoice has not been delivered by the operational creditor, and the disciplinary proceeding. So what all are they saying? They said you have to deliver to that person a demand notice. They said you have to deliver a demand notice to the other person. Okay, so if you have not delivered, your application can get rejected. If there is a dispute, it can get rejected. If there is no repayment. Okay. So they basically here the section talks about the positive covenants. Admission, if the application is complete, there is no repayment, the invoice or notice has been delivered, no notice of dispute has been received, and there is no DC. Rejection is just the negative conditions. Application is not complete, demand notice has not been delivered, or the operational creditor has been repaid, or the notice of dispute has not been received. Okay, has been received and there is no dispute has been initiated, or there is a DC. So these are the conditions for rejection. However, before rejecting, they shall give time to the applicant to respond. So this is within 7 days, and corporate insolvency resolution process shall commence from the date of admission of the application under this section. Okay, so we've now finished 3 sections, which is 7, 8 and 9. We'll now go to 10 in the next video.